stop scrolling right now, because what I'm about to tell you could completely change your rights as an American. 2 explosive Supreme Court rulings just dropped, and they don't just affect someone else, they affect you, your family, and every interaction you have with law enforcement or your firearms. I'm going to break down shocking court decisions that could expand your protection against police overreach and reshape gun rights across the entire country. By the time you finish this video, you'll understand exactly how these rulings impact your life, and the truth will shock you. Trust me, you cannot afford to miss a single second of what comes next. Before we dive in, do me a quick favor, hit that subscribe button. I promise, this channel is made just for people like you who want the real story, not the watered-down version you see everywhere else. I'm bringing you these topics first, breaking them down in a way no one else does, and I'll be uploading more content like this, so you can stay ahead and know exactly what's happening. Subscribe now. It only takes a second, and you won't miss a single important update. Hey, what's going on, everybody? Welcome back to the channel. Today we are diving into something that every single American needs to hear about, and I mean that from the bottom of my heart. We are talking about 2 absolutely massive Supreme Court rulings that have changed the way your constitutional rights work in this country, and I'm talking about both your Second Amendment rights and your Fourth Amendment rights all in one conversation. Now, I know that might sound like a lot to unpack, but trust me, by the time we're done here today, you are going to understand exactly what happened, why it matters to you personally, and what it means for the future of America. So grab a drink, get comfortable, and let's break this thing down together. First, let's just take a quick second to talk about what the Second and Fourth Amendments actually are, because a lot of people kind of gloss over that, and if you don't know what the foundation is, none of the rest of this is going to hit the way it should. The Second Amendment is the one that guarantees your right to keep and bear arms. It's the Gun Rights Amendment. It's the one that people argue about constantly, the one that gets debated on television, in Congress, in barbershops, at dinner tables. It's one of the most talked about amendments in the entire Bill of Rights. Then you've got the Fourth Amendment, which protects you from unreasonable searches and seizures. That means the government, including the police, cannot just walk up to you, violate your personal space, go through your stuff, or put their hands on you without a legitimate legal reason. The Fourth Amendment is your shield against government overreach. It's what stands between you and law enforcement doing whatever they want without any accountability. Both of these amendments are incredibly important to everyday American life, and both of them just got redefined by the highest court in the land, and every single justice agreed. Now let's start with the Fourth Amendment ruling because it's important, it's dramatic, and it hits close to home for a lot of people. The case is called Barnes versus Felix, and it was decided unanimously on May 15th, 2025. 9 justices, all of them, agreed. Not a single dissent. That almost never happens in cases this significant. And the fact that it did tells you something very important about how clear-cut the legal issue was once it was laid out before the whole court. Here's the story. Back in April of 2016 in Houston, Texas, a police officer named Roberto Felix pulled over a man named Ashtian Barnes. The reason for the stop? Suspected toll violations, not a robbery, not a violent crime. Toll violations. So Officer Felix walks up to the car, asks Barnes for his driver's license and proof of insurance. Barnes tells him he doesn't have his license and that the car is actually a rental in his girlfriend's name. Barnes starts rummaging through some papers in the car, and Officer Felix tells him several times to stop digging around. Then Barnes starts to drive off. The car begins to move. At that moment, Officer Felix jumps up onto the door sill of the moving vehicle and fires 2 shots into the car. Ashton Barnes was hit and killed. The whole thing, from when the car started moving to when it stopped, was about 5 seconds. 2 of those 5 seconds passed between when Felix stepped up onto the car and when he fired those shots. Now Barnes's family sued, arguing that Officer Felix used excessive force and violated Barnes's Fourth Amendment rights. But here's where things got really interesting, and honestly, where the legal system showed a serious flaw that had been building for years. The case went to the Fifth Circuit Court of Appeals, which covers Texas, Louisiana, and Mississippi, and the Fifth Circuit had what they called the moment of the threat doctrine. Now what that means in plain English is this. When a court is deciding whether a cop used too much force, the Fifth Circuit said you could only look at the exact moment the officer felt threatened. You couldn't look at anything that happened before that moment. You couldn't consider how the situation started, what led up to it, what the officer did to create or escalate the situation. None of that. Just the final second or two right before the trigger was pulled. Think about how wild that is for a moment. Imagine you're on a jury and you're trying to figure out whether someone acted reasonably, but you're only allowed to see the last 2 seconds of a 10-minute video. You can't see what started the confrontation. You can't see whether somebody antagonized the situation, made threats, drew a weapon first, or anything like that. You're just looking at the very end and making your whole judgment based on that tiny sliver. That's what the Fifth Circuit was doing, and they had been doing it for years. And under that rule, courts said that whatever Officer Felix did before jumping on that car was completely irrelevant to the analysis. Since Felix could argue his life was in danger at that specific moment, the lower courts said his shooting was legally justified. Case dismissed. But the United States Supreme Court said absolutely not. All 9 justices said this approach is flat out wrong and has been wrong the whole time. Justice Elena Kagan wrote the opinion for the court, and she explained it in a way that just makes common sense once you hear it. She said the Fourth Amendment has always required courts to look at the totality of the circumstances. That phrase means everything, the whole story, the full picture, not just the last frame of the movie. You have to consider how the encounter started, what crime was suspected, whether the officer gave warnings, what the person did throughout the encounter, and all the steps that led to the moment of force. The Supreme Court said that by only looking at the final moment, the Fifth Circuit was essentially putting what they called chronological blinders on the courts. It was forcing judges to ignore critical context that could completely change how a situation looks. Here's a real-world analogy to make this crystal clear. Let's say someone pushes you and you punch them in the face. If I only show the jury the moment you threw the punch, it looks like you just randomly attacked someone. But if I show them the full video, they see that the person had been threatening you for 10 minutes and shoved you first, and suddenly the punch looks completely different. Context matters. Common sense says context matters. And now the Supreme Court has said under the Fourth Amendment, context always matters when evaluating whether a police officer used reasonable force. This ruling means that across the entire country, every court is now required to look at the full story when judging whether excessive force was used. It's a massive expansion of accountability for law enforcement, and it gives families of people who were killed or harmed by police a much fairer shot at justice in court. Now let's talk about the Second Amendment side of this conversation, and this one is going to surprise a lot of people depending on which way you lean politically. The case here is called United States versus Rahimi, and the Supreme Court ruled on it on June 21st, 2024. This one was an 8-1 decision, with Justice Clarence Thomas being the lone dissenter, but it's important to the broader conversation about how the Supreme Court is reshaping gun rights in America, and it connects to a whole series of recent rulings that are fundamentally redrawing the lines around your right to bear arms. Here's what happened. A man named Zaki Rahimi was under a civil protective order, which is what courts issue when someone has been found to be a threat to another person, usually in a domestic violence situation. Under federal law, specifically a statute called Section 922G-8, if you are subject to one of those protective orders, you are prohibited from possessing firearms. Rahimi was found with a gun and was charged under that law. His defense argued that the law was unconstitutional and violated his Second Amendment rights. The Fifth Circuit actually agreed with him at one point, saying that the government couldn't justify the firearms ban based on historical tradition. But then the case went to the Supreme Court. To understand why this matters, you need to understand what happened just 2 years earlier in 2022 in a landmark ruling called New York State Rifle and Pistol Association versus Bruen. In that case, the Supreme Court completely changed the standard for how gun laws are evaluated. Before Bruen, courts would weigh the government's interest in public safety against how much a law burdened your gun rights. After Bruen, the Supreme Court said that's not the right test anymore. Going forward, the government has to show that any gun regulation is consistent with the historical tradition of firearm regulation in America. In other words, the government has to prove that something similar to this law existed back at the time the Constitution was written or shortly after. That was a seismic shift, and it opened the door to challenges against all kinds of gun laws across the country. So then Rahimi came along right after Bruen, and everyone was watching to see how the court would apply this new historical test. What the Supreme Court said in Rahimi was that yes, even under the new historical test from Bruen, it is constitutional to temporarily disarm someone who a court has found to be a danger to others. Chief Justice John Roberts wrote the opinion and pointed to historical laws from the founding era of America that allowed communities to disarm people who were considered threats to public safety. The idea that a dangerous individual could be temporarily disarmed is not new. It existed in early American law. So under the Bruen framework, the modern federal law passes the test. The court was very careful to say this ruling is narrow. It applies specifically to people who have been found by a court to pose a credible threat to another person's physical safety. It's not a blanket statement about all gun restrictions, but here's where it gets really significant for gun rights in America. The Rahimi decision set up important guardrails for the historical test from Bruen. Justice Roberts made clear that the historical test doesn't mean you have to find an exact copy of a modern law in a 1791 law book. Instead, courts need to look for historical analogs, meaning laws from the founding era that addressed similar problems in similar ways. This matters enormously because there are dozens of gun laws across the country right now that are being challenged in courts under the Bruen framework. Laws about assault weapons, high-capacity magazines, background checks, age restrictions, and more. Every single one of those cases is now being argued using these two Supreme Court decisions as the foundation. Rahimi tells us that laws protecting people from credible threats of violence can survive constitutional scrutiny, but it also reaffirms that the historical test is the law of the land, which means laws without a solid historical foundation are still vulnerable to being struck down. So now let's zoom out and talk about why these two rulings together, the Fourth Amendment ruling in Barnes versus Felix and the Second Amendment ruling in Rahimi, are so significant as a pair. Most of the time when we talk about constitutional rights in America, we talk about them in silos. Gun people talk about the Second Amendment, civil liberties folks talk about the Fourth Amendment, but these two decisions, both unanimous or near unanimous, both reshaping major areas of constitutional law, tell a much bigger story about where America is right now when it comes to individual rights and the relationship between citizens and the government. The Barnes versus Felix decision expands your protection against government use of force. It says the police cannot be shielded from accountability just because someone can argue they felt threatened in the final moment of a confrontation. The full story has to be told. This is huge for communities that have long argued that the legal system has made it nearly impossible to hold officers accountable, even when the facts suggest something went terribly wrong. Now the courts have to consider everything, and that changes the calculus for how cases are litigated, how settlements happen, and ultimately how police departments train their officers. The Rahimi decision, while it upheld a gun restriction in this specific case, does something even more important in the big picture. It defines the rules of the road for how gun laws will be tested going forward. It says the historical test from Bruin is real, and it has teeth, but it's not a time machine. Courts can't pretend America is stuck in 1791. They look for principles and analogs from history, and if those exist, modern laws can stand. If they don't exist, those laws are in serious trouble. This means that over the next several years, America is going to see a wave of gun law decisions from courts all across the country, all of them flowing from these Supreme Court rulings, and the landscape of gun rights in every single state is going to look very different when the dust settles. What makes both of these rulings particularly powerful is that they were decided unanimously or near unanimously. In a country where everything feels divided, where every Supreme Court decision seems to split along partisan lines, these rulings stood apart. On the Fourth Amendment, every single justice, from the most conservative to the most liberal, agreed that courts have to look at the full picture when evaluating police use of force. That kind of agreement doesn't happen by accident. It happens when an idea is so fundamentally correct and so rooted in the plain meaning of the Constitution that no reasonable interpretation can push back against it. And on the Second Amendment, 8 out of 9 justices agreed that protecting people from credible threats of violence has deep roots in American legal history. What this all means for you as an everyday American is this: if you ever find yourself in a situation involving law enforcement, the Fourth Amendment now has a stronger set of teeth. If force is used against you or someone you love, the courts are now required to look at the whole story, not just the final moment. That doesn't mean officers lose every case, or that police work becomes impossible. Good officers making split-second decisions in genuinely dangerous situations are still protected, but officers who created dangerous situations through reckless or unreasonable behavior can no longer hide behind the final moment as a legal escape hatch. On the gun rights side, if you're a law-abiding gun owner, the Supreme Court has made clear it is actively scrutinizing gun laws through the lens of history and tradition. Laws that have no historical backing are going to face serious legal challenges and may not survive. But the court has also said that reasonable regulations with historical roots can and do stand. This is not the court saying the government can do whatever it wants with gun laws, nor is it saying there can be no restrictions at all. It's charting a middle path grounded in the actual history of the country. Together, these decisions represent something rare in modern America: a Supreme Court that is willing to take both the rights of citizens against government overreach and the historical foundation of gun rights seriously at the same time. They reflect a court that believes the Constitution means something specific, and that meaning has to be respected whether it cuts in favor of more accountability for police or in favor of more protection for gun owners. And the fact that these rulings came down without serious dissent suggests that even across the ideological spectrum on the court, there is a bedrock of agreement about what the Constitution actually says. The bottom line is simple. These are not just legal technicalities. These are decisions that affect real people in real situations every single day in America. The next time a family goes to court after a deadly encounter with police, the totality of the circumstances will have to be heard. The next time a gun law is challenged, history is going to be put on trial right alongside the law itself. This is your Constitution being interpreted in real time, and as an American citizen, you deserve to understand exactly what that means. Thanks for watching. Make sure you share this with someone who needs to hear it, and we'll see you in the next one.